Ocala.
All right, 24 minutes before 11 o'clock. Thank you for tuning in. It's time for the program called Legally Yours. It is hosted by John B. Fuller. He's in the studio. John is an attorney at the law firm of Fuller and Fuller right here in Ocala, and he'll answer your legal questions right now. And, of course, during the course of the show, he'll also give information so that you can sit with John in his office and speak more intimately about whatever circumstances you are facing. The number right now is 622-9622. That is the WOCA Climate Control Source Hotline. 622-WOCA. And just so you know that this is a live show or not, today is Wednesday, April 9th, 2014. So if your calendar shows Wednesday, April 9th, 2014, you're listening to a live show and you're invited to call in. Good morning, John.
Hey, good morning, Larry. Good morning to our listeners. It's always nice to be here and to be with you and the folks that are kind enough to listen to this program, and anyone who has a question that involves a legal issue that we can generally talk about, we'd be happy to do that. If it's about the legal system, we'll try to address that. But as I always say, if a person is involved in an accident or has a pending controversy that is time-wise critical, they need to make an appointment, and we'd be happy, of course, if they'd call the office if it's something that we practice in, which is litigation and Social Security disability, to see them and handle their case on a one-on-one basis, because we're limited here to talking in general terms.
And there was a question last week. I already gave you a heads up, I guess, on this one. Last week, you were probably not even at your car, and the phone was ringing, and I answered it, and the gentleman was asking for you. And I had told him you already left the studio, so I told him I would ask you the question. And, sir, if you're listening and I get it wrong, please call in and ask John. It sounded like there's three parts, that his nephew was in an accident. And he's not from Florida, but he was asking if Florida had the no-fault law in place, and if so, what does that mean? And if it means that nobody's at fault, then why is his nephew, and of course I don't know the details here, but why would his nephew need to prove that he was not at fault if there's no fault law? And so,
well, that's a pretty involved, we were talking about it just before we went on the air. Let me just speak in general terms, and there are some exceptions, but I assume the accident happened in Florida. Florida has a no-fault auto accident law that applies in certain circumstances and to a certain extent. We've talked about on this show in the past. Your first level of coverage is available to any driver who's in a car accident, regardless of whether that individual is at fault or not. If you are injured in a car wreck, you have personal injury protection benefits that pay 80% of your medical bills and 60% of your lost wages, provided that you seek medical attention within 14 days of the accident, and you only, to qualify for that, must see a medical doctor, an osteopathic physician, a physician's assistant, or an advanced registered nurse practitioner who sees you for the injury in the accident and certifies that it's a significant medical event. Then you have your $10,000 that you've paid for available to cover your first round of medical bills and lost wages up to the extent of your policy limits, which in most policies is $10,000. It can be greater if you've bought a policy and paid more. But that's available regardless of who's at fault. Even if you're parked at a stoplight and somebody crashes into the rear of you, you get your PIP first. Now, after you exhaust your PIP, or even if you don't necessarily exhaust your PIP, if as a result of the negligence of one of the drivers in the accident, you suffer a permanent injury, a permanent impairment, significant scarring or disfigurement, or death, you meet then what is called the tort threshold. Tort meaning the ability to go to court and sue someone for civil negligence. In that case, you would personal injury protection coverage, which is available regardless of fault, covers only medical bills and lost wages. Okay? If you have a significant injury, one that qualifies as permanent, then you have a claim for all the other elements of damages that one can suffer as a result of being injured in an accident. For instance, pain and suffering, mental anguish, loss of ability to enjoy life, loss of ability to perform the activities of daily living, future medical bills and expenses, future lost income. Your spouse, if you're married, has a consortium claim which he or she can recover on for the loss of the marital relations and companionship and doing the things that the injured spouse used to do but can't do.
Right.
And, if he always mowed the yard and now he can't, and the spouse has to go out and mow the yard or hire it done, that's an element of damage. You can then make a claim for those. In order to prevail on that, you must prove by the greater weight of the evidence that the other party was at fault, was negligent, breached the standard of care, that as a result of that breach of duty, they caused the accident, which was the cause of your injuries,
right.
And as a result of the injuries, you suffered damages.
And so ultimately, you're suing. This might have come up last week. That might be why he called in. But I feel like we had this discussion. You're suing the.
You're suing the individual,
not the insurance.
No, their insurance company has a fiduciary duty to come in and defend them, and if a judgment or verdict is returned, they then have to pay the amount of that verdict up to the extent of their policy limits. And
so that's why.
And Florida has a comparative fault state. So if two cars are at an intersectional collision, one car ran a stoplight, the other car was speeding, and there is comparative negligence, the jury is asked to allocate what percentage of negligence goes to driver A and what percentage goes to driver B. If driver A has sued driver B and he or she is found to be 50% at fault, and gets a $100,000 verdict, there is a net $50,000 recovery after deducting the $10,000 PIP.
Oh, okay. And you do have another phone call.
Very good.
Good morning. You're on the air with John Fuller.
Good morning, sir.
Good morning. How are you?
Oh, pretty good. And you?
Great, thanks.
Good. I got a question. I don't know if you remember the Pitts and Lee trial where they were accused, I guess, of murder, and then they were later found out they were exonerated after spending several years in prison. When I knew they had to go before the state and they were, compensated, I guess, mildly, but you can never compensate anybody, I guess, when they spend almost 20 years or more in prison for something they didn't do. But my question is, when they find that a state's attorney or prosecutor, whatever, has deliberately withheld evidence that they knew would have helped find that person not guilty, are they liable in any sense, or can people come back after them, or are they totally without any liability? I'll hang up and listen to you.
Thank you. That's an excellent question, and yes, I do remember the Pitts Lee case almost from its inception. I was a very young lawyer at the time. It was at the trial level. But the bottom line is that the prosecutors in the state of Florida have absolute immunity from being sued, even if it is established that they knowingly and willfully withheld evidence in order to obtain an invalid conviction and there's a subsequent reversal, the prosecutor is immune from prosecution. The state attorney, who's an elected public official and a constitutional officer, not only enjoys immunity from prosecution, but he is exempt from any type of sanctions by the Florida Bar Ethics Division, which would oversee the conduct of behavior of all other lawyers in the state of Florida. So the only remedy that one would have, it would be an impeachment proceeding, because the state attorney is a constitutional officer. You would have a claim for compensation. You see these cases. I agree with you that first of all, there has to be a determination that their conviction, have to get their conviction reversed. Once that happens, it's up to the Florida legislature to determine a compensatory package, and I agree with you. Those things take several years at best to get the legislature to rule on it, and the amount that people recover, in my view and in my judgment, the ones I'm familiar with, fall very short of coming anywhere close to making a person whole. Our system of justice, working at its best, doesn't have a magic wand that can give somebody their life back or give somebody their health back. The only way that the system has to try to make someone whole is with a monetary award. But there is no claim other than that I'm aware of, and I've never handled a case like this in my career, but is for a claims bill through the legislature, where you have to find a legislature who will sponsor a bill, and it's usually a relatively modest payment when you look at the overall suffering.
Now, there was that lady who was in prison for a long time because she fired a warning shot. Remember that story? And now they're considering adding the warning shot to the stand your ground ruling.
Yeah, I've seen that. I think that would be a terrible idea to put in a part of our law, shooting a warning shot. That is contraindicated. It's not taught in any of the defensive shooting schools, handgun defense shooting schools. It's not taught to law enforcement officers. There's far more danger in firing a, quote, warning shot that you're going to injure an innocent bystander. The use of lethal force should be reserved for when you are facing a threat of significant bodily harm or death to yourself or others. And I think, this idea that somehow the stand your ground law needs some other check and balance, and putting in a requirement that before you do that, you shoot a warning shot. I think it is, if you talk to all of the experts in the application of lethal force in self-defense, or in the application of lethal force by law enforcement officers, it is universally taught that it is not a good idea to fire a warning shot. Where do you shoot the warning shot? Up in the air? That projectile has to come down somewhere, and people can be killed with that.
Yeah, she shot it into the ceiling.
Where do you shoot it? You shoot it on the ground. If you shoot it on the ground and you're on concrete or asphalt, the bullet will ricochet at about a 95-degree angle off of the horizontal and run parallel to the ground.
You want to go phone?
Okay, phone call. Let's go.
Thank you. Good morning. You're on the air with John.
It pays to be a safe distance from anybody that likes to discharge a gun, evidently. Mr. Fuller, we have a neighbor here whose son was involved in a multi-car accident here a while back. No injuries, but a lot of property damage, car damage. At the scene of the accident, when the police arrived, he revealed a lot of information and more or less stated that he was at fault for a certain amount of the accident, later on in contacting his lawyer more or less bawled him out for giving out any information in that area. What is the a legal situation on that as far as how much information do you have to give, or what should you do?
Well, if the law enforcement officer is investigating an accident, there is an accident investigation privilege. So that information that is given to a law enforcement officer in the initial stage of investigating an accident is privileged and cannot be used against you in a subsequent criminal or civil case. If the law enforcement officer, in the course of investigating the accident, after he gets the information for the accident report, the accident investigation report, he then has a duty to shift hats or to change hats and to inform the driver that he is no longer doing an accident investigation, but he believes there is probable cause that there has been a criminal offense committed, and he is going to inquire in connection with a criminal investigation, and consistent with that, then a person's rights under the Constitution to remain silent, to have a lawyer present, if one's not available, to have one appointed at no charge to the individual if they're indigent. The traditional Miranda rights attach once you become a target of a criminal investigation, even if it grew out of an accident investigation. But they can't mix and blend. So if you tell them things that are in response to their accident investigation, then it should not be admissible unless there are other technical exceptions that I'm not addressing because we don't have a specific fact pattern here, but that's the general law.
Okay, thank you.
My pleasure.
And thank you. The phone number right now, if you'd like to call John Fuller, is 622-WOCA. That is the WOCA Climate Control Source Hotline. You're invited to call. The phone was lit up during the last call. I could see another call trying to come through. So if you bailed out and want to call now, the line is open. So with firing a warning shot, if you haven't had firearms training, that you just own a gun, and you decide, I don't want to shoot that person, I just want to shoot into the air, I don't want to shoot that person. Obviously, you've already pointed out the dangers of doing that, but that would not be considered a way to defend yourself?
Well, it's not recommended. There are no legal consequences unless you fire the warning shot and the person or some person is injured. However, if there is a question as to whether or not you truly were faced with a lethal force situation where you were in imminent danger of great bodily harm or death, if you pull a weapon, you display a weapon, and you discharge a weapon, there are other criminal offenses. Even if you don't shoot somebody, there's other criminal consequences, such as aggravated assault with a firearm, which carries mandatory prison sentences, reckless display of a firearm.
Which is, I think, what that lady was in prison for. But
yeah, it's a highly, and I understand that that the court thought that the result was too harsh and sent it back to be retried, and I can see where that would be. Someone could be well-meaning with that, but and she may be ultimately right. I mean, that may in those circumstances not be considered anything other than a preparatory act to lawfully defend yourself in an appropriate scenario. I'm not saying that it's necessarily against the law, but there are things at risk where if you have a gun and you display the weapon, you can be charged with assault, aggravated assault with a firearm, and all of those are serious criminal cases. You can also be charged with something lesser included than that, which is a reckless display of a firearm. Yes.
And yes, sir, you have another phone call. Good morning. You're on the air with John Fuller.
Hey,
good morning.
Fuller, I've got a concealed carry permit for probably 25, 30 years. Thank God I've never had to use my firearm. But this warning shot stuff is completely ridiculous. The only time you ought to ever use your firearm is if you are in defense of your life.
Absolutely. That's a very good point.
Harm for you or your spouse or people around. And why anybody would want to put a law out there that authorized somebody to do something that reckless is totally beyond me. Where did that come from anyway? Do you know?
Well, I think the unenlightened intellect of our legislators. I apologize if I offend anybody with that, but you asked my personal opinion. I think it's probably a bunch of people who watch too much television, know very little, if anything, about the law and the dynamics of using a firearm in self-defense. And I think it is just a manifestation of very poor judgment and the desire to want to do something, and a lot of times less is more. But that's just my personal opinion on it. I would not advise any client of mine to display a firearm and to fire a warning shot. If the situation is escalated so that you are in such imminent danger of severe personal injury or death that it's necessary for you to display the firearm, you're almost at a point. You obviously want to try to give a verbal warning, like and they don't say something like freeze like they do on the movies. It's basically the command is don't stop. Get down, I'm calling 911, something like that.
Yeah, the only time anybody will ever see my firearm is just before I pull the trigger.
Well, it's difficult. It's difficult to deal in absolutes. Like we've said before, the devil's in the detail, and those are very serious matters. It's a very wonderful right that Florida has. It was the first state in the country to pass a shall issue law. Now I think all but about 2 or 3 states have passed similar laws and give other states reciprocity. And I think that's a wonderful, wonderful thing. I commend you. I commend you for doing it and getting the appropriate training. But one thing that people need to understand, and Jeff Cooper, who was a master of the modern pistol craft, he's dead now, but he developed Gunsight Academy to teach people and special forces and law enforcement people how to effectively defend themselves with a handgun or a weapon. And Jeff Cooper pointed out that just because you buy a Stradivarius violin doesn't make you a violinist any more than buying a handgun makes you capable of using that. It is an inert tool, and if someone is going to do it, they ought to take the time to take appropriate training. And I'm not just talking about the basic level course to get the concealed weapons permit, although that obviously is a good start, but to go take appropriate training and to shoot enough. Shooting is a fungible skill, and something that one should do on a regular basis to make sure that they have the rudimentary skills in which to appropriately and adequately and safely deploy that weapon to defend themselves if the circumstances warrant it.
You may know that no responsible firearms instructor would ever put forth this premise of firing a warning shot.
That is consistent with all of the information, training, and knowledge that I have in the subject, and I'm by no means an expert on it, but I agree with you.
Neither am I, but you have to keep up with the laws and the changes and everything to be able to legally carry it. Most people are really confused about this anyway. The law only gives you your firearm concealed. It don't give you any right to use it other than right.
Yeah,
I think that's a fair statement.
Yeah, you
Thank you for calling in.
Got it. Thank you.
Thank you for your program. It's always informative.
Thank you, sir. That was very kind. I appreciate that.
And if I could just interject the news from Thursday, I'll just read the first line. This was from the Tallahassee, whatever the newspaper is up there. The Florida Senate on Thursday, so that would have been last Thursday, approved the so-called warning shot bill, moving to significantly revise the state's self-defense laws for the first time since the shooting death of Trayvon Martin. So they are connecting it, at least the news media is, with the Trayvon Martin Zimmerman.
Well, it isn't the first time that I vehemently disagree with what the Florida legislature does, but we only have each of us one vote at the ballot box, which reaffirms why it's important to exercise your right to vote and vote the best qualified people into those positions.
And obviously, you illustrate that you're the best qualified person. If we need an attorney, how do we get a hold of you?
Well, I certainly wouldn't go so far as to say that. There's a great hue and cry by the bar right now that if you say anything about your abilities, it has to be independently verifiable, and subjective statements is the best, and that sort of stuff are frowned upon. So I'm not saying that. We do care about our clients, and we are conscientious about trying to help. And if people have legal questions, you can call us at the office at 352-547-4292, and the toll-free number is 855-534-2565.
Okay. John Fuller, thank you so much.
Thank you, Larry.
Call us here at WOCA if you need John's number repeated. We'll be glad to do that for you. Or go to WOCA.com, look at the guest list for this show, and you'll see John's name at the 1035 slot, as well as his phone numbers and website himself. We'll take a little break. We'll be right back.
Your home is safe, or is it? AA Lock, Dock, and Security. The name has been a staple in Ocala since 1985. Do you have the right equipment in place to have peace of mind when you are at home or away? AA Lock, Dock, and Security has the right people to install and monitor your home